Good morning, I'm Gary DeWaal, and this is Bridging the Week for July 17th to 21st, and today is July 24th, 2017. A broker-dealer agreed to pay a fine of $2.5 million for alleged violations of its Financial Industry Regulatory Authority and other SRO obligations to report large option positions timely and accurately. In addition, two firms resolved disciplinary actions for purportedly violating the prohibition against transitory exchange for related position transactions by CME Group exchanges. A pole of high heat and humidity settled over the northeast United States this past week and does not appear to be leaving anytime soon. So I can try to find a cool place to escape from this unpleasant weather as soon as possible. Let's get started. Goldman Sachs & Co. agreed to pay a fine of $2.5 million to resolve charges brought by the Financial Industry Regulatory Authority that, from at least January 2010 through July 2016, it failed to report or accurately report over-the-counter option positions in approximately 21 million instances in the large options position reporting system hosted by the Options Clearing Corporation. FINRA also claimed that Goldman Sachs failed to resubmit a large number of OTC records that were rejected by the LOPR system and violated position limits for OTC options in 3 different securities. Among other things, at various occasions, GSCO or Goldman Sachs failed to aggregate positions for acting in concert purposes for certain customers, submitted records with various formatting issues, over-reported option positions, and failed to delete from its LOPR report positions with incorrect effective dates charged FINRA. The majority of Goldman Sachs' fine is payable to FINRA, while the remainder is payable to 3 exchanges. Generally, FINRA requires members to report or have reported on their behalf any options positions in any account or multiple accounts where the firm or any customer, whether alone or in concert, maintains an aggregate position of 200 or more option contracts of the put class and the call class on the same side of the market for the same underlying security or index. A Chicago Board of Trade and a Chicago Mercantile Exchange member each agreed to settle exchange-brought disciplinary actions that they entered into exchange-related position transactions that were transitory in nature and thus prohibited. In one action involving Alphadyne Asset Management LP, a CBOT member, the firm agreed to pay a fine of $65,000 to resolve charges that, on November 3, 2015 and March 1, 2016, it entered into EFRP transactions involving U.S. Treasury futures to rebalance positions held by various Alphadyne funds that were contingent upon execution of other EFRP transactions. CBOT claimed these transactions were executed without incurring market risk. Unrelatedly, Barclays Bank plc agreed to pay a fine of $15,000 to settle CME charges that had also engaged in a transitory EFRP on April 5, 2016. According to CME, the bank sold E-mini S&P 500 futures and bought SPDR S&P exchange-traded fund contracts while simultaneously selling the SPY contracts and buying S&P 500 index option combos against the identical counterparty. CME claimed the SPY contracts were entered into and liquidated without Barclays incurring market risk. CME Group exchanges do not permit transitory EFRPs for any purpose. CME Group says that an EFRP is transitory when the execution of an EFRP is contingent upon the execution of another EFRP or related position transaction between the same parties, and the related positions are offset, quote, without the incurrence of market risk that is material in the context of the transaction, end of quote. And finally, a U.S. Federal Court of Appeals sitting in New York City set aside the conviction of Anthony Allen and Anthony Conti, 2 former Rabobank traders, for their alleged role in the bank's manipulation of London interbank offering rates through the LIBOR submission process at various times from mid-2005 through 2011. The court set aside the 2015 conviction of the 2 traders because of the use of testimony they were compelled to give to UK regulators in their U.S. trial. According to the court, the Fifth Amendment's prohibition on the use of compelled testimony in American criminal proceedings applies, quote, even when a foreign sovereign has compelled the testimony, end of quote. Separately, the U.S. Attorney's Office in New York City announced that it was dropping all criminal charges against Javier Martin Atajo and Julian Gout for their alleged role in J.P. Morgan Chase credit default swaps trading in 2012 that resulted in a loss to the bank of over $5.8 billion US, the so-called London Whale incident. Among other things, the prosecutors believed they could no longer rely on the testimony of Bruno Ixel, the so-called London Whale himself, a former colleague of the two defendants, because of his public statements and writings. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article, and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, stay cool and ciao.